ladies and gentlemen, Joy Stephen from the Polinsys Studios, and here is another case law for the Student Herald, Lewis versus Canada. Now, case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada or the fairness in the process for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters, and judgment for this case is attached in my blog reportersreport.com as a PDF document. Now, this is an immigration case law and includes topics like exclusion and expulsion, removal orders. Applicant was Guyanese national who came to Canada in 1966 and lived in Canada as permanent resident for almost his entire life. Applicant had criminal record with 4 assault convictions. Last conviction in 2003 resulted in admissibility hearing where he was granted 1-year stay. Applicant's housing became unstable after he obtained stay, and he became homeless, and he failed to update his address with Immigration Appeals Division. In 2007, applicant became aware that there was an immigration warrant for his arrest. Applicant was arrested but was released on bond. Applicant had young daughter who was registered native Indian, and he was granted sole custody of her in 2011. Removal order was issued. Applicant applied for permanent residence on humanitarian and compassionate grounds and requested deferral of removal. Officer refused request for deferral of removal and found it was beyond her authority to perform adjunct humanitarian and compassionate evaluation. Applicant applied for judicial review and application was dismissed. Standard of review was reasonableness. There was no legal basis for submission that child's rights under S7 of Canadian Charter of Rights and Freedoms would be engaged or breached by applicant's removal. Charter submission was premature as alternate remedies were not exhausted. Child's charter rights were not engaged by applicant being removed from Canada. Child was Canadian citizen and was entitled to leave and re-enter Canada. Child lacked standing to raise S7 interest on behalf of applicant as she was not being extradited or removed from her heritage except by choice and actions of appellant. Rights protected by S7 did not include rights of parents and children not to be separated by state action. Deportation of parents of Canadian-born Aboriginal children did not violate S7 rights of either parents or children. Officer was sensitive to the best interests of child and reasonably considered child's short-term interests. Officer's decision was reasonable. Lewis versus Canada. It's dated November the 25th of 2015 from the Federal Court. Thank you.